Hello, and welcome to the Brinks 2016 IP Developments webinar. My name is Kim Norwood, and I will be in the background answering any Adobe Connect technical questions. If you experience technical difficulties within the Adobe Connect session, please use the Q&A box on the right-hand side of your screen, and our technical assistant team will help in any way possible. If you are having issues hearing over the phone, you may press *0, and an operator will assist you. Please note that as an attendee, you are part of a larger audience. However, due to maintain privacy, the number and names of attendees will not be displayed. All attendees will be in the listen-only mode throughout the presentation, and as a reminder, today's call is being recorded. We will be holding a Q&A session at the conclusion of today's presentation. To submit a question, click on the Q&A panel located on the lower right side of your screen. Type your question into the text field and hit send. Please keep the send to default as all panelists. This seminar is accredited for 1.0 hours of Illinois MCLE credit. Please inquire if you wish to seek CLE accreditation in additional states. During the webinar, we will be providing 3 CLE codes. Please write these down. We will be mailing evaluation forms at the end of the webinar and will ask for the codes. If you have any questions regarding CLE, please contact cle@brinksgilson.com. With that, we invite you to sit back, relax, and enjoy today's presentation. I would now like to introduce today's moderator, Jim Sobieraj. Jim, now you have the floor.
Good afternoon. My name is Jim Sobieraj, President of Brinks Gilson Lione. In today's program, we will focus on some important developments that occurred in 2015 that will have lasting effects in 2016. We will also highlight significant developments we see coming down the road in 2016. At Brinks, we like to think forward to solve our clients' immediate intellectual property needs and provide long-term IP strategies that align with their business goals. We've built today's program around that foundation of thinking forward. At Brinks, we have a deep roster of more than 135 attorneys and scientific advisors with experience in every aspect of IP law and in every field of science and technology. I'm really pleased today to have 4 of my stellar colleagues as speakers on today's panel: Beth Miller, Bill Frankel, Mark Remus, and Amy Fix. You'll see on the screen now today's agenda. Mark and Amy will go first. They will be discussing post-grant proceedings and how these proceedings impact ANDA litigation strategies. They will be followed by Bill Frankel. Bill's going to talk about fair use in the digital age and what do some recent fair use decisions portend for copyright protection and enforcement. And our final speaker will be Beth Miller. She will address the impact of administrative proceedings in IP protection and enforcement and how the Supreme Court's recent decision in B&B hardware will have some lasting effects. Again, we do welcome your questions. You can send them in during the course of the presentation. After Laura's finished, I'll ask for questions, so it won't be too late. You can submit your questions at any time. So with that, why don't we get started? Mark and Amy?
Thank you, Jim, and welcome, everyone. Our first topic is directed to inter partes review proceedings in the Patent Office, and we will offer a few comments that are specific to pharmaceutical patents, but a lot of our thoughts apply to all IPRs and really transcend all technical subject matter. One of the hottest topics in 2016 is going to be the issue of claim construction in IPR proceedings. The PTAB, or PTAB, applies what is known as the broadest reasonable interpretation standard. Under that standard, the Patent Office considers the words of the claim and then assigns those words the broadest interpretation that is consistent with the specification of the patent. That is arguably broader than the standard that is applied in the U.S. District Courts. In the U.S. District Courts, judges are not looking for the broadest reasonable interpretation, but instead the correct interpretation in view of all of the evidence and particularly it takes into account the various canons of claim construction, including claim differentiation, prosecution history estoppel, and disclaimer. And that's the standard that was set forth in the Federal Circuit's Phillips case from 2005. Now, the difference in claim construction standards between the PTAB and the U.S. District Courts has been the subject of much debate, but in 2016, hopefully we should get a little bit more clarity. On January 15th, just a couple weeks ago, the Supreme Court granted certiorari in the first IPR case to make its way through the Federal Circuit, and that's the Cuozzo Speed Technologies versus Lee case. One of the issues to be resolved in the Cuozzo case is whether the PTAB's broadest reasonable interpretation standard is the correct standard for use in IPRs. We expect a decision before the Supreme Court summer recess, which puts a decision approximately late June or early July. Of course, the big question is, what is the Supreme Court going to do, and how will that decision impact PTAB proceedings, specifically IPRs? I don't have a crystal ball, none of us do, but we do want to share some thoughts on where the Supreme Court may come down on this claim construction issue. It's my opinion that the Supreme Court will overrule the PTAB's use of the broadest reasonable interpretation standard. And there are two reasons for that. First, historically, the Federal Circuit does not do very well with the Supreme Court. The Supreme Court generally doesn't grant cert in a patent case when it sees something that the Federal Circuit got right. Instead, it's only going to grant cert if it sees something it doesn't like. And that is why historically, the reversal rate for Federal Circuit patent cases at the Supreme Court is around 80 to 90%. So just on the numbers alone, it suggests there will be some change to the claim construction standard. Second, this claim construction issue goes directly to one of the principal reasons for why the Supreme Court exists in the first place, and that is to create national uniformity. Typically, for example, we will have a circuit split, where maybe the First Circuit sees things differently than the Second Circuit. The Supreme Court will get involved to create some uniformity. Well, we have a similar situation here. We have two courts, the PTAB and the U.S. District Courts, construing the same claims using two different claim construction standards and potentially arriving at two different claim constructions. I don't think the Supreme Court is going to like that. One of the strongest canons in patent law is that claims should have the same meaning for validity as they do for infringement. Right now, claims are construed broadly at the PTAB for purposes of validity, but potentially more narrowly by the district court with respect to infringement. And that's not a desirable situation. And I think, it's my opinion, that the Supreme Court will agree that claims should have the same meaning regardless of which forum you are in. So if the Supreme Court reverses and changes the claim construction standard for IPRs, what impact will that have on PTAB proceedings? For a lot of cases, in fairness, it won't make much of a difference. Claims mean the same regardless of whether or not you're taking into account disclaimer or estoppel, because there aren't any disclaimers or estoppel. But for a significant number of cases, it'll make a big difference. As we all know from district court litigation, prosecution disclaimers and estoppels can have a huge impact on the meaning of a claim term. They will have a huge impact on IPR proceedings too. For example, if a patent owner disclaims subject matter during the original prosecution, that will narrow the claim scope and possibly avoid prior art. The result of having narrower claims as a result of enforced disclaimers or estoppels is that we may see a lower rate of institution and a lower rate of invalidity findings under the narrower claim construction. The other change that I think we'll see if the Supreme Court reverses the claim construction standard is that briefing in front of the PTAB will become more rigorous. It will become much more like a fact-intensive proceeding that we see in the district courts through Markman hearings. The result, however, will be a better, more uniform claim construction where claims have the same meaning in the PTAB and in the district courts. I wanted to offer just a couple specific comments on how a potential change in the claim construction standard applies to pharmaceutical patents. I think it's unlikely to impact how compound patents are evaluated in front of the PTAB. Claim construction issues are not as common or as important in looking at compound patent cases. However, where I think we will see some differences of opinion are with respect to formulation and method of treatment cases. For those cases, it is much more common to see examples of disclaimer or prosecution history estoppel in the original prosecution. And those disclaimers and those estoppels will create narrower claims, as a result, encompass less of the prior art. As a result, I think for the formulation and method of treatment cases, we'll see a lower rate of institution and perhaps a commensurate reduction in the rate at which those patents are found invalid. I'm now going to turn it over to my colleague, Amy Fix.
Thanks, Mark. And picking up on where Mark was sending us with respect to specifically the pharmaceutical arts, the current statistics show that for petitions filed in the relevant art units, the majority are alleging 103 obviousness. There's still a fair number that are alleging novelty. However, clearly, most are making obviousness challenges. We have a relatively even amount with 416 being denied and 391 being granted. So there is a clear increased use of the IPR in the pharmaceutical arts. However, the amount that are being granted versus denied is relatively even. The issues, however, just like Mark said, is a question of uniformity. And with respect to the institution of the IPR in the first place, that seems to be the key, that if the IPR is going to be instituted, at least one claim will be affected. So on the patent owner side, the emphasis seems to be on not allowing the petition to be granted in the first place. Where on the petitioner side, if you get your petition instituted, the likelihood of finding at least one claim invalid seems to be very likely. Specifically, some of the emerging issues that are evolving in the pharmaceutical field is the complex framework of Hatch-Waxman litigation and having IPR proceedings upset that framework. There seems to be some concern on the brand side of a deprivation of the ability to litigate in district court, where it's required that under Hatch-Waxman that ANDA disputes are resolved in district court litigation. Because the district court can stay the litigation pending the IPR proceedings, brands feel the balance has been upset. And most recently, just in December of 2015, in the Southern District of Indiana, Eli Lilly had their litigation stayed pending the IPR, but the district court judge refused to similarly extend the 30-month regulatory stay, saying that a corresponding extension of the regulatory stay preventing FDA approval of the underlying ANDA was rejected because there's no law that justifies this request. So there's definitely a conflict between the administrative proceedings of the IPR, the district court proceedings, as well as the regulatory proceedings before the FDA. On the generic side, however, the IPR offers a fantastic forum for technical argument. Again, with respect to an obviousness challenge, like Mark said, especially on a formulation or method of treatment case, there's usually very technical or multi-reference obviousness challenges. And those are much better suited to the PTAB, where, in fact, previously considered prior art still serve or can serve as a strong basis for the invalidity. Often, it seems, the idea of using a selective invalidity strategy may work for the generic side, that using the district court for the 101, 112, or inequitable conduct arguments, but making their novelty and obviousness arguments before the PTAB, and developing a strategy that actually uses both processes to their best advantages. As Mark mentioned, the standard of claim construction right now is a different standard between district court litigation and the PTAB. In addition, how the evidence is viewed in order to overturn a claim is currently not uniform either. In addition, before the district court, there's a presumption of validity, whereas that presumption just doesn't exist for an IPR challenge. And it can make it very difficult for a patent owner to make arguments or amend their claims during the IPR process because, again, in the IPR and the lack of discovery efforts, a patent owner may amend their claim that then avoids infringement of the competitor's product because they don't have the benefit of the discovery to know that their amendment would still have a commercial impact. In addition, one other consideration is the idea of a first filer. With respect to first filers, first ANDA filers, the incentive for the IPR does not appear to be as strong. Again, the district court can stay the litigation for the IPR, but potentially the 30-month regulatory stay will not be impacted. And if that happens, and an Orange Book patent is invalidated through the IPR proceedings, which in turn, after appeal, could then impact the district court proceedings through, for example, a motion for summary judgment, potentially that could then serve as a decision that then triggers the forfeiture provision. So the first filer is not necessarily in the best position when it comes to using an IPR strategy. Later filers, however, appear to be at a distinct advantage and could, in fact, trigger that first filer's 180-day exclusivity. On the other side, on the patent holder side, like I mentioned, the petition does appear to be the key point, that if the emphasis needs to be on not allowing that petition to be granted in the first place. Some strategies that could be used are large claim sets, or perhaps in the past, often a patent would include claims to many different aspects of the invention, whether it's the composition, a pharmaceutical composition comprising the composition of matter, methods of treatment, or salt forms or other polymorphic forms. It appears that it would benefit the patent holder to spread their claims over multiple patents, if for no other reason than to inhibit a petitioner on the basis of the filing fee. Right now, the filing fee is $23,000 per petition, and if you can spread your claims over multiple patents, it may provide some disincentive to a petitioner. In addition, there are strict petition requirements, and a multi-layered obviousness challenge is going to take a lot of room to explain. So the more layered your claim, the benefit. That would benefit a patent holder, excuse me. And then in addition, consider having layered claim strategies to strategically narrow certain claims to avoid prior art and address infringement and be able to incorporate dependent claims into independent claims to hopefully maintain commercially relevant claims, but at the same time have fallback positions for use during the IPR. One additional thing that I wanted to bring up about the ability of the petition for the patent holder is that the USPTO can use their discretion to deny the petition, and that may be a strategy for brand companies in a Hatch-Waxman area, that neither the AIA nor its legislative history suggests any absolute right to be granted an IPR. And in the Hatch-Waxman context, ANDA disputes must be heard by the district court. So again, as Mark mentioned, the ability for uniformity and not having multiple forums for multiple to have different opinions as to the same patent, it would appear, at least in the Hatch-Waxman context, there may be duplicative efforts between the district court and the PTAB such that a patent owner could petition the USPTO and say that the more appropriate forum for this dispute would be the district court. And my last point was the idea of creating leverage. Now this again lends itself more to the petitioner side, where the IPR offers a less expensive and quicker resolution, and in fact you can file the IPR at an earlier stage of product development. For example, if your development efforts can in fact challenge a patent, perhaps even before the patent is licensed to a large pharmaceutical company, there may be quite a bit of leverage in how you can manage the relevance of that patent to your final commercial project. In other words, that if you could challenge a patent when it's still in the hands of either a small pharmaceutical company or in the hands of a university, then the ability to have that patent, to avoid that patent is much larger. And also the ability to attack any Orange Book listed property, whether or not it's asserted in the paragraph 4 litigation, would definitely be a benefit to a petitioner. So now let me turn it over to, oh, I'm sorry, there's our first CLE code. Jim, do you want to make that announcement?
Yes, it's important that you record the CLE code.
And that code is BGL 27952.
Can you repeat it one more time, please?
Sure. BGL 27952.
Okay. Yeah, these codes are important because you need that to qualify for CLE. Okay, our next speaker will be Bill Frankel. Bill?
Good afternoon, everybody, and to all the colleagues, friends, and clients I see on the line, welcome to today's presentation. I'm going to switch from the world of IPRs and ANDA to copyright, and I'm going to tell you a little bit about the recent, or last year, decision by the Second Circuit in the Google Books case. But before I do that, I want to give you a little context, because this is all about fair use. What is fair use, and why does it matter? Fair use is an exception to the exclusive rights of copyright. So it exists statutorily to avoid the rigid application of copyright in a way that might stifle creativity. So for example, Section 107 of the Copyright Act tells us that certain uses are permissible and encouraged, like criticism, comment, news reporting, scholarship, research. So these are things that even if they involve some level of copying, do not necessarily constitute infringement. In fact, fair use is an exception to copyright infringement. If there's fair use, then it's a get-out-of-jail-free card. There's no infringement. The statute says that we should look to 4 non-exclusive factors guiding the fair use determination. No one of these factors is dispositive. The 4 factors are the purpose and character of the use is the first factor. If the work is of a commercial nature, that might weigh against fair use when compared to something that's for a nonprofit educational purpose, for example. The second factor is the nature of the copyrighted work. Is it fictional or is it a factual work, the latter being more likely to be found to be of fair use? The next third factor is the amount and substantiality of the portion used in relation to the copyrighted work as a whole. Has the borrower taken 2 lines out of a 600-page book, or have they copied 3 verses out of a 4-verse poem? And then lastly, the fourth factor is a very important one, the effect of the use upon the potential market for the copyrighted work or the value of the copyrighted work. Because if the second work, the borrowed work, impacts the value of the original work in an adverse way, that prejudices the original copyright holder, and that does not weigh in favor of fair use. So the seminal case in this area is Campbell versus Acuff Rose, a Supreme Court case in 1994. And this is where the Supreme Court first explored the contours of fair use. The case involved a rap parody by Two Live Crew of the Roy Orbison song Pretty Woman. They came out with a rap parody called, I think it was Big Hairy Woman, with some raunchy lyrics. The court analyzed this and concluded that this was a transformative and a fair use. And this transformative use notion, the court pulled out of the first fair use factor, purpose and character. The court said that the central purpose in our fair use analysis is to see whether the new work merely supersedes the objects of the original creation, or instead whether it adds something new with further purpose or different meaning or different character, altering the first with new expression, meaning, or message. In other words, whether and to what extent the work is transformative. This was the first time that the courts had introduced this transformative use notion into the copyright fair use analysis. But I'll show you that it actually originated 4 years earlier. I just want to focus your attention on the language altering the first work with new expression. This is a key concept that you'll see come into play later. So what is transformative use? Well, it was first suggested as a tool by a judge, Judge Pierre Laval. He coined this term in a 1990 Harvard Law Review article. And what he was talking about at the time was something that copyright people knew to be what were called productive uses. In other words, where a borrower comes and bestows their intellectual labor to rework selections from a prior work, that's okay as long as they're not prejudicing the profits or the prospects for the original work. Those are considered productive uses, and that's what Judge Laval was trying to get at. Criticisms, parodies, summarizing an idea in an article, etc. Now, and this is the same transformative use notion that the Supreme Court applied in the Campbell decision. Now, I'll give you an example of what's happening. The transformative use notion is actually starting to morph into something called a transformative purpose. And the Grateful Dead case is an interesting example of that. This is where the defendant, the Dorling Kindersley Ltd. company, came out with a coffee table book that was about the Grateful Dead, and it had small images from Grateful Dead concert posters in the margins of the book. And the book was all about the history of the Grateful Dead and various events, and corresponding to the events were these images. And there was clearly a taking of the entirety of the images. There was no adaptation or manipulation of the original images. They were just plopped right into this coffee book. And so the action was brought for copyright infringement. The publisher argued this is fair use. It's not infringement. And the court, the Second Circuit, agreed in 2006 that this was a transformative use because the images in the book were being used to tell a story and to document facts about the Grateful Dead. They were not being used as substitutes for the aesthetic posters, if you will. So this background brings me to the Authors Guild case. That's the main subject of today's discussion. And this goes back 15 years to a case that the Authors Guild filed in 2015 when Google launched something called the Library Project. Now put yourselves back in 2005. This company, Google, had only gone public the year before. And at that time, people were reading hard copy books. There were no such things as Kindles. There were no iPads. There were no smartphones that you could read a book on. And Google came up with this radical approach. They went to a number of libraries, including Harvard and Oxford and University of Michigan, and they pulled up in trucks and they hauled away the libraries of books and they copied them. They digitized them. And what their objective was to create a searchable library of books. So if you wanted to find some information that you recalled from a book, you could plug in a search box in Google. You could look up, it was the best of times, it was the worst of times, and the search would take you to what Google presented as a snippet, a small snippet of the text from the Dickens book, and you would be able to see a few lines before and a few lines after the search text, and that would give you context. And there'd be links on the page if you wanted to go to Amazon or to BarnesandNoble.com at the time. You could go and you could purchase the book. So this wasn't a substitution for buying the book. It was just Google's argument was they were creating a searchable database. The problem was that this had turned copyright notions completely on their head because up until this time, when anyone wanted permission to use copyrighted material, they went and requested permission. Here, Google went ahead and made the copies and then asked for forgiveness when they were sued in 2005. The case went through a number of procedural skirmishes. A class of authors was eventually certified, and Google reached a settlement with this class of authors. Unfortunately, the court didn't like the deal, and it was scuttled in the settlement. It was scuttled in 2013. So the case went back down to the district court. A motion for summary judgment was filed by Google that this was fair use, what they were doing, and the district court, Judge Chin, agreed, largely on the theory that this was a transformative use. The Guild appealed a few months later. The case made it up to the Second Circuit and was decided in October of last year. And interestingly, the decision was authored by the very Judge Pierre Laval, who had first introduced this notion of transformative use. And the court concluded, the Second Circuit concluded, that Google's copying was transformative within the meaning of the Campbell versus Acuff-Rose decision. That Google wasn't offering a substitution for the original books, and that the statutory fair use test was met. So just to run down the four fair use factors quickly, as the Second Circuit did, the purpose and character of the use here, the court emphasized the snippet views. The court found that the purpose was to make significant information about books available rather than making the books themselves available. So Google prevailed on the first fair use factor. The nature of the work, the court found that to be a neutral factor. There's been a good bit of commentary about whether that was correct or not. The third factor, the amount and substantiality of the portion used, There was no question that Google had copied the entire book, but the court felt that this copying was reasonably necessary to achieve Google's transformative purpose, which was to enable full-text search functionality. And then finally, the court addressed the effect of the use on market value. Interestingly here, the court said this factor is, quote, of great importance, end quote. And what the court determined here was that the snippet function, this function that Google used to show just a small portion of the book, did not give researchers access to the entire book, and therefore didn't impact the value or the market for the original books. Now, the Authors Guild petitioned to overturn this Second Circuit ruling just a month ago, on December 31, 2015. And their arguments, as well as the arguments of the critics of transformativeness, are basically, this is an impermissible expansion of the original concept of transformativeness, number one. Number two, the argument's being made that transformativeness has become the blob that swallowed up the fair use doctrine to the exclusion of the other fair use factors enumerated in Section 107, the other three factors I identified at the beginning of this discussion. So these are the arguments that are being made to the Supreme Court. There's also a split in the circuits here. The 3rd, 6th, and 11th circuits have ruled that works must be expressively altered in order to get the benefit of this transformativeness argument. And you'll recall that this was the language that the Supreme Court used in the Campbell case, expressively altered language. Whereas the Second Circuit, the Fourth Circuit, and the Ninth Circuit seem to be moving towards this transformative purpose argument. And if a work serves some kind of a higher purpose, a public benefit, then that weighs in favor of a transformative and a fair use. The Seventh Circuit, in a decision out of Wisconsin last year, criticized the Second Circuit and said that this transformative definition is too broad, and really the market factor number 4 is the more important one. It's hard to say where the Supreme Court is going to go with this case, whether they'll take it. Despite all the criticisms and the apparent expansiveness of the fair use doctrine, the Second Circuit did consider all the 4 fair use factors. It gave a nod to the importance of the 4th fair use factor, and also bear in mind that this was a particularly unique case because Google was doing something here that was factually unique. They were digitizing books to make them searchable. So I'm going to briefly touch upon some of the takeaways from this decision and how it might impact different areas. One of the things the court emphasized was that the intended beneficiaries of copyright are the public. And so this transformative purpose of benefiting the public weighed heavily in the Second Circuit's decision. Obviously, the landscape has shifted to a more hospitable one, as you'll see shortly, for digital copying and for secondary uses of art. Another takeaway is that just because a work is commercial doesn't mean that it can't be a fair use. Parodies, news reporting, things that are done for profit can be a fair use. And conversely, works that are transformative and may have a public benefit may not be a fair use if they destroy the economic value of the original work. The one implication I want to touch upon briefly is derivative works, because there's some confusion here as to how do you implement transformativeness but still respect and recognize that under our Copyright Act, authors have the ability to create derivative works, such as a translation of a novel into another language, or the adaptation of a novel into a movie or a play. These are rights that the author has, and how do you reconcile that with this transformative notion? The court, the Google court, did that by saying that derivative works are actually transformative forms of a particular work, whereas the fair use analysis looks to the transformative purpose of the work. bit of a hard explanation to get your arms around, but that's how the court dealt with it. Let me just mention a few areas where I think this case is going to have a lot of implications. One of them is in the art world, because appropriation artists and other copyists are going to try to justify their copying of the entirety of works as fair use. And we've seen that in art cases already involving Jeff Koons and Richard Prince and the like. In fact, most notably, or most recently, Richard Prince was sued over the Instagram photos you may have read about late last year. Prince took these photos right off of Instagram of people, and he blew them up as big images, printed them on museum quality paper, framed them. He modified them slightly, and he wrote some words on them, put them in a gallery in New York, and because of his notoriety, these works, some of them sold for as much as $90,000. And really, they were copies of portraits taken by a photographer, and that photographer has now sued him, and that obviously will be a fair use battle. But in the art world, one wonders how it is that judges are going to make the subjective determination of what is a transformative use of art. Another area where I think the Second Circuit decision could have some impact is with respect to the Digital Millennium Copyright Act. Recall that that act sets up the procedure whereby content holders can send a notice and takedown letter to a service provider with posting information that contains copyrighted material. And in the case of Lenz versus Universal Music Corp., Stephanie Lenz created this video of her son, that's him on the left, dancing to Prince's Let's Go Crazy. And it was a 30-second clip. She posted it on YouTube, and Universal Music Group started sending her notice and takedown letters. And she refused, saying, it's my right to post this, it's fair use. And she eventually sued Universal Music Group. After 8 years of litigation, in September of last year, the Ninth Circuit ruled in favor of Lenz. And many people view this as a victory for the fair use doctrine. It wasn't a decision that this was necessarily fair use. Rather, what the Ninth Circuit said is that content owners must consider the fair use doctrine thoroughly before sending takedown notices. And if they don't, they can get in trouble. And so that's something that we as a firm are doing for our clients now on a daily basis, providing them with a fair use analysis before we send takedown letters on their behalf. But that fair use analysis is obviously implicated by decisions such as the Google Books decision. I want to briefly mention software. There's an Oracle dispute with Google that's been up to cert, denied at the Supreme Court. It involves application programming interfaces. It's a very closely watched case. Initially, the argument was made by Google that these works weren't protectable, as they weren't copyrightable, they weren't original. Federal Circuit rejected that argument. The case is now back down at the district court, and Google is now arguing that copying APIs is fair use. We'll see where that goes. And then the last fair use battleground that I have time to mention today is exemplified in a case that was filed in 2013 involving the iconic Thomas Franklin image photograph called Raising the Flag at Ground Zero. This was taken after 9/11, and on the 12-year anniversary of the 9/11 attacks, this image was posted by Fox News on its social media sites. They were sued for infringement by the owner of the photograph. The case settled last year, and one of the issues that the jury would have had to grapple with had the case gone the full distance to trial is the extent to which posting in the world of social media is necessarily transformative on the theory that the content at issue is being used in a transformative context as part of a conversation. And this issue is still very much out there and alive. It applies, for example, in the case of home videos synced to music and posted on YouTube. Is that necessarily a fair use because it enters the music into a social conversation. Very interesting area. So that concludes my discussion of fair use. And in the remaining time, I want to turn this over to Laura Miller, who has an interesting discussion about the ITC.
Okay.
All right.
Thank you.
Can you pause yeah.
CLE first. So, Kim, if you're online and can give everyone their second CLE code, please?
Yes. The code is BGL 96274. Again, that is BGL 96274.
Okay, thanks, Kim. And thanks, Bill. Copyright's always an interesting topic. So, hi everyone, this is Laura Miller. The third topic today involves another Supreme Court decision, this one B&B Hardware versus Hargis Industries. And in this case, the Supreme Court addressed the question of whether or not an agency decision, in particular the Trademark Trial and Appeal Board, or the TTAB as I'll refer to it today, whether or not the agency decision could have preclusive effect in a subsequent district court case. Now for patent folks on the phone, this is an important decision because it may have implications beyond the TTAB and may impact decisions of both the Patent Trial and Appeal Board, the PTAB, or even the ITC, where before this case we thought this question was resolved. But to start, let me give you a little bit of background on the B&B Hardware versus Hargis Industries case. And if after this talk you find the facts, you want to know a little bit more, go back and read it because it is by itself a very interesting study in the interplay between TTAB decisions and district court decisions. And there was a lot of back and forth over a number of years. The TTAB is an administrative agency. It's responsible for evaluating and registering trademark applications. Much like PTAB, it has a quasi-judicial function. It handles inter-parties disputes concerning validity or registrability of a mark. And those are issues that can and do arise in district court as well. So in this case, Hargis Industries was actually the first user of the trademark Seal-Tite, spelled T-I-T-E. It was using that mark in connection with self-drilling and self-piercing screws and hardware that were used in post-frame buildings and metal frame buildings. These products, as you might imagine, are a few cents a piece. B&B Hardware was actually the second user of the mark Seal-Tite, spelled slightly differently, T-I-G-H-T, but sounds the same. It was using it for similar but different hardware. It was using Seal-Tite in connection with self-sealing hardware, nuts, bolts, things that contain O-rings to help in the sealing process, and the products were specifically designed for the aerospace industry. So in addition to the slight difference in hardware, the channel of trade, the purpose of the product was different, and the price point was different as well. B&B Hardware, however, was the first filer at the first to file its mark and get a registration for the mark Seal-Tite. Due to a series of what I would call unfortunate events, Hargis attempted but failed to properly challenge and remove that B&B registration from the trademark registry. So what happened is when Hargis went to register its own mark, B&B opposed the registration, and the TTAB concluded that Hargis was precluded from challenging the B&B registration on the ground of priority. So that left only the question of whether or not the marks were confusingly similar. When the opposition, and that's what the issue the opposition proceeded on. What were the two marks, seal tight, T-I-T-E, for hardware, confusingly similar to the registered mark, seal tight, T-I-G-H-T, for hardware in the aerospace industry. At the same time the TTAB proceeding was going on, B&B filed and pursued a trademark infringement case against Hargis, arguing likelihood of confusion. TTAB resolved the question first, finding confusion based on the record in front of the TTAB. The district court, however, found that that TTAB decision was not, did not have preclusive effect for two reasons. One, the TTAB was not an Article III court, and second, the issue of likelihood of confusion is not the same in the TTAB as it is in district court. The Eighth Circuit affirmed that. The issue was taken to the Supreme Court. The Supreme Court accepted the case in part because there was a split in the circuits. And in considering the question of whether or not likelihood of confusion, a final finding in the TAB would have preclusive effect in a district court litigation, the Supreme Court said yes. It said a court could give preclusive effect to a TTAB decision if the ordinary elements of issue preclusion are met. And in the context of a likelihood of confusion situation, it specifically said one of the elements to consider is whether the usage of the mark considered and adjudicated at the TTAB are materially the same as the usages that would be considered before the district court. So, those of you who are familiar with issue preclusion, you may be saying, well, why is this result surprising? Because in some sense, the Supreme Court was just saying, apply issue preclusion as you would in any ordinary non-IP case. And that's kind of a theme that you see with Supreme Court cases when they're considering IP cases. They tend to say, IP issues are no different than other issues. The same rules should apply. But for TTAB petitioners, this was an interesting decision because the TTAB considers the question of likelihood of confusion in the context of registration of a trademark. It doesn't consider it in the context of actual use of that mark. The TTAB looks at the marks really in the abstract. It compares them almost just side-by-side comparisons, which is not, again, the way a district court looks at the situation. A district court looks at the situation in the context of the marketplace. How do these marks appear to the consumers who are actually purchasing or likely to purchase the product? So on a substantive level, the decision was interesting. On a procedural level, it also was interesting. As the Eighth Circuit and the District Court had noted, the TAB is not an Article III court. It's an administrative tribunal. It engages in a very streamlined procedure. In general, there's no live testimony. Everything's on written papers. Even the types of survey evidence that is used is different. In general, market factors, actual use are not considered. And they wouldn't normally, in the normal course of things, even be in the trademark application and in the opposition record. So in contrast, as I said, the district court kind of looks at what is the real-life activity that's going on, not what was anticipated or what's on the paper record, what's going on in the marketplace, and is there likely to be actual confusion in the marketplace. But notwithstanding these differences, the Supreme Court concluded that, in general, the TTAB, which applies the DuPont factors, is applying the same legal principles as the district court, which also relies on the DuPont factors to determine likelihood of confusion. The case, because of its kind of tortured history, had the evidence in the opposition proceeding that the district court would likely consider when it was considering, if it were considering a likelihood of confusion factor. And that was a significant part of the decision behind the Supreme Court's conclusion that the TTAB decision could have preclusive effect. It also wanted, at least in my opinion, to reiterate the idea that there should not be bright line tests, things like absolutely never can a TTAB decision have preclusive effect. So what's the upshot of all this? Are the TTAB decisions now going to have significant likelihood of preclusive effect in the subsequent district court decisions? Probably not. The Supreme Court case reiterated that you still have to meet the ordinary elements of issue preclusion, meaning the parties have to be the same or in privity. That's likely to be the case. The issue has to be the same, and the issue actually has to be litigated and resolved on a final judgment that takes those factors into account in reaching the judgment. In the context of likelihood of confusion, that's often not going to be the case because, as I've explained, this idea of usage of the mark, the evidence that the TTAB is going to consider is often going to be different than what a district court would consider. So what are some strategies in going forward that we should think about in 2016 and onward now that we have this B&B decision in front of us? What can we expect? Clearly, the stakes are going to be higher or could be higher for the parties in the TTAB proceedings. People have to give more consideration as to what evidence they're going to put in the record. It could be that particularly the senior user may want to go full board and put a lot of evidence in, hoping to get a preclusive effect, a decision that would have preclusive effect in the subsequent district court proceeding. On the other hand, if you don't know a lot about what the other party has done in the past, you may want to hold back. So you can see this going either way, depending on how much early knowledge you have about the other party. In the past, TTAB proceedings had been a good way to kind of test out and find out what the evidence is. Now that strategy may be put in question given the potential impact of TTAB. There's also another issue to consider, though. Even if you do put all this evidence in, the TTAB itself is going to have to rely on that evidence in making its decisions. And it's quite possible that even if you put this evidence in, the TTAB is going to hold back and not actually make its decision based on these marketplace factors. Other things to consider if you do get an adverse TTAB decision or you anticipate one, or a district court action is actually filed during the pendency of the TTAB, is to move to suspend the TTAB proceeding so that you can get all of the evidence, including marketplace evidence, considered first by the district court. If that doesn't work, TTAB proceedings are interesting or unique in the sense that you can actually ask for de novo review in front of a district court if you get an adverse TTAB decision, and you have an opportunity to put in new evidence. You don't have to immediately appeal that TTAB decision to an appellate court. What are some things to look forward to in 2016 outside the context of the TTAB? I think there's two areas at least that came to my mind. The first is the ITC. The Federal Circuit previously said back in 1996 that because of the nature, this quasi-judicial nature of the ITC being an administrative agency, and because of some suggestion in the legislative history, though not in the statute itself, it is held that ITC decisions do not have preclusive effect in subsequent district court decisions. I think we can expect that decision to be challenged. And in fact, over the years, a number of district courts and litigants have tried to whittle away at that Texas Instrument case decided by the Federal Circuit. I think we'll see another push in that direction now with the B&B hardware. Another area, I think, is that patentees, particularly if they're successful in overcoming post-grant challenges before PTAB, will try to push for preclusive effect. So far, the district courts have been reluctant to do that, to expand the preclusive effect of PTAB decisions beyond what the AIA actually allows. But with the Supreme Court case in the Cuozio case that Mark mentioned, and particularly if Mark's crystal ball prediction is correct, and there's a change in the PTAB's claim construction standard, bringing it more in line with district court, you can expect that there will be another effort to, at least for successful litigants, to get those PTAB proceedings to have preclusive effect in district court. So with that, those comments, I'll conclude and turn this over to Jim to see if we have time for a few questions and answers after Kim gives us the third CLE code.
And that code is BGL 83419. Again, the code is BGL 83419.
Okay. Thank you, Kim, and thank you, Laura, Beth, Bill, Amy, and Mark. We're running a little long today. I know people's schedules are important. People have their commitments. So what we'll do with respect to the questions is if you sent us a question, we'll have one of our presenters respond to you directly. So let me just conclude by thanking everybody for listening into today's seminar. We hope you found it informative and helpful. As new developments occur throughout the year, our firm prepares client alerts, which are succinct summaries of new developments with practical tips on likely ramifications. We send these client alerts out by email to our subscribers. If you're not on our mailing list and would like to receive our client alerts, please send an email to any one of us. You can find our contact information on our website, which is also another source of helpful information and updates regarding intellectual property. The URL for our website is brinksgilson.com. Thank you again for listening, and best wishes for a successful year in 2016.